Okay, so I guess in light of the weather, let's see what players are missing today. So I had Jadida, your DCF. We don't have any district attorneys here, so.
We can just have a discussion if you want.
Remind me, Ash, because I knew you were going to talk about something.
That was Tim.
That was Tim? Okay, yes. And there was someone else. Nadej, okay, good. So we'll start with you guys. So we have Tim representing Alicia, Ash representing Jason here, Nadej, Jonathan, Lester and John both for Lee, Jadida for DCF. I'll try to bring up the criminal issues, okay? And yes, I mean, we need to summarize. I want to get into, you know, sort of all the issues that were covered in this case, and it's just tremendous. All the, you know, and when I tell you more about the real case, there's even more convoluted, you know, things that happened. So let's have a really quick discussion and try to tie up if you think that all of these parties could possibly arrive at some sort of, you know, package deal on the criminal and on the care and protection case. Nadej, let me start with you because you're Jonathan's counsel, and I don't remember if I asked you anything specifically, but if you could comment, and I know some of the case law does talk about in care and protection cases specifically, when you know, when children, you know, in a family, more than one child, 3 children, 4 children, and so forth, are all the subject of a care and protection petition, and perhaps there aren't any specific allegations or very little or really very little evidence as to one child or more. What does the court generally say? What is the law generally as to whether, you know, a judge can find a father and mother unfit towards a child that's in a group of children in a family that is the subject of a care and protection case that goes to trial? Do you know what I'm saying here? So, for example, your client, Jonathan, has, you know, there's no allegations, no evidence of child sexual abuse by his biological father, Lee. So even, in a sense, maybe more of a claim, you know, in terms of parental rights. Yet your position is that he should be free from alleged abuse and neglect, and that he should continue in the custody of the department. So where's sort of the law behind you to have that particular strategy? And if a judge agrees with you, you know, and I'll open it up to everybody else, would the judge err? Is that, suppose she took the opposite position, and yet the judge, you know, found all 3 children in need of care and protection, would Nadej, as counsel for Jonathan, have an appellate claim that the judge had erred?
Well, they usually, the judges usually look at the totality of the evidence and the proof that they have. So they won't really focus on Jonathan, but the whole evidence.
Okay. What else do you have? And that certainly is a piece of it. What do you mean by the whole, the totality?
Exactly what happened to Alicia and Jason, Justin report, and so they combine all these evidence together, and you know, most likely the judge will find what's his name again, the father, Lee, unfit, as an unfit parent, because the judge might be worried about Jonathan being harmed in the future.
Okay, that's another good point. What do the cases say about either future fitness or future unfitness?
we have,
And in light also, let's consider her first point as well, that certainly a judge can consider that the child who's not harmed is still looked at in terms of the totality of the abuse and neglect. I'm going to use your own words, abuse and neglect to all of the children. In particular, the McHale case that you have, which a few of the cases that I gave you in this package were not typically child sexual abuse cases, but they dealt with some of these issues. And McHale is the case that I call it the cake frosting case. That's the way I remember this one. I just see the scene because the kids were allegedly, eating cake frosting for lunch. So that's how I remember the McHale case. But anyway, one of the issues that the appeals court considers is, I guess, one of the children, and I think it was Oscar, and I can't remember if he was younger or older, but I guess he had sustained like less emotional damage than the others. And these words may ring a bell for you guys. The appeals court says a judge does not have to wait for disaster to happen. In determining parental fitness, a judge may use past conduct to predict future ability and performance. Judge was entitled to focus on the constant inability or unwillingness of the parents to cooperate, and then they go into other issues. So even though there's no evidence that the younger child here, Jonathan, was abused, it could be possible that the judge would not be overturned on appeal based on that contention. Again, she, her position might have been otherwise because she's substituting judgment. So depending on the facts and the circumstances of the case, she could be advocating return home, and yet judge could, rely on this proposition, and it may be a basis for appeal. Judita?
My question was, do they also consider the steps the parents take as far as rehabilitation for themselves?
Absolutely, and when you say that isn't really the word, but it's cooperation with the service plans, especially when, the service plans are pretty much about every 6 months or so. So depending on the age of the case, by the time it gets to trial, there could be tons of, service plans. In fact, if it's even going to go to the termination stage, those are also considerations that what we call the 210 factors. There's 14 factors, and many of those factors deal with the unwillingness or parents just being unable by status of whatever the condition is to really comply. Ash, you wanted to say something?
I was just going to say they would justify the removal of the children from custody of the parents, depending on their unwillingness to comply with the service plans or even their consistent inability to.
So that was the the point and the reason why I specifically appointed a separate counsel for the younger child rather than counsel for all three children. Or obviously the reason that I appointed Ash, you and Tim separately was because I had Jason being younger than 10, so we can consider the 233 exceptions. And just to quickly summarize those exceptions now. 81 is the criminal exception, and because of the important due process and constitutional procedural rights of defendants in criminal cases, there are more stringent standards in 233A1. So remember, we went through and Jeremiah had mentioned it as the district attorney. Unavailability, and that could be a number of different reasons. In this case, he argued, well, it would have been traumatic for the children to testify, and thus they're unavailable. And if the Commonwealth even wants to introduce out-of-court statements, children under 10 in a criminal sexual abuse prosecution, they've got to do it ahead of time before trial. They have to give notice. They have to show an availability. The hearing itself has a standard, preponderance of the evidence that there's a compelling need for this procedure, and they've got to demonstrate both reliability and corroboration. Now it's funny because 82, which we didn't deal with because, you know, DCF's mission so far, DCF's purpose was only loss of custody in terms of the camp protection case. Jadida had mentioned, and so did Richard earlier, that they weren't moving for adoption or termination. But if they did, then 82 might apply as well, and that was the Quentin case. The SJC also held in the Quentin case that, you know, because the loss of now parental rights altogether is so much more serious than just the loss of custody in a care and protection case, that the procedures for introducing out-of-court statement of children in adoption cases are pretty much almost the same as the criminal. Yeah,
well,
Lester.
The court stated that termination of parental rights is the equivalent of a liberty interest.
Yes.
And so therefore must be held to a much higher standard.
Absolutely.
To a shadow of a doubt.
And in fact, there was another case, adoption of Carlos, that didn't deal with the statutory issue, but there's some very good language in adoption of Carlos, which explains the differences between care and protection case and a 210 an adoption case, and how the termination case is so much more serious. And you'll find that that in many cases SJC or appeals court may reverse and remand on termination, where the parents are unfit at trial, but it's just not enough, right, for the final step of termination. So yes, good point. And finally, with 233A3, which would have been the process that Jadida and Richard in the care and protection case, if they wanted to introduce Jason's statements in the care and protection case, much less stringent standard. They don't even have to have a separate hearing. It could be a voir dire, could be an argument before the judge, and they just have to convince the judge that these statements would be reliable. So more than likely, Jason's out-of-court statements would be coming in the care and protection case. And again, they only would come in the criminal prosecution if all of those, you know, steps were taken, and if the judge ruled that in fact there was reliability and cooperation and so forth. Where was I? I just lost where I was.
Can I ask you a question? It's a little bit, I don't know if we're going to talk about later, but it's sort of about the article about the role of the attorney.
Yes, I do. You can bring it up right now if you want. That, you know, I believe I have all of the issues on the board. Okay. That this case study hasn't it? Hopefully, there may be more than what I've got on the board. Yeah, go ahead, bring up your.
Well, I guess my basic question is, it seemed like an argument could be made for advocating for the child, and it also, whether or not, even if you, like, even if you don't believe it's in Jonathan's best interest to go back, he wants to go back, and so you serve the client's best interest.
Again, yeah, and substitute of judgment, no matter that he's 4 years old, if he could make this adequately considered decision, if he was mature enough, would he want to be with his biological dad, or would he want to be free from harm, so to speak, right?
And I guess my question is, do the lawyers, when they try to go for the best interest of the child, or do they get in trouble? Do they get disciplined?
Okay. This was interesting because, as I said to you before, when the case first started, you know, by statute, all of the parties get counsel. So the 3 children were appointed counsel. Now, at the time, remember, they were living with Uncle Tony. So was that the third? So they spoke first to Ellen Kathy, then the same interview. Okay, so then the DA wanted to interview them. So this would have been the third time that they were talking to someone. So Tony brought them to the DA's office, and something happened. He got pissed off, or the kids were crying, or they didn't want to talk, and their attorney was there as well, and he fired the attorney, the court-appointed attorney, and then
hired his own.
And hired his own. So DSS at the time filed some kind of motion. I can't remember what it was, and I think it was to recuse or to something to do with getting rid of, the conflict of interest. It was conflict of interest because they were saying that, oh, he's the brother, then in actuality it's Lee who's funneling all of this and, directing it and maybe even paying for it and so forth. So the judge did not allow DSS's, I'm saying DSS because they were called DSS back then, not allow DSS's motion, but appointed the GAL. As you probably guess, I was the GAL. And it was very astute of that judge back then to appoint a GAL, because here's the thing, in terms of role of counsel issues come up also. Attendant to that is a possible, attorney privilege issues as well. So, for example, you represent the child, okay? And Jason, for example, this applies more to Jason and Alicia than Jonathan because he's too little to articulate anything. But Jason and Alicia are telling you, we don't care. We want to stay home with that. We didn't engage in anything with our dad. Even if we did, we want to stay home. All right. And so, or they even tell you what happened, but say this is what we're directing you to do as our counsel. Okay. So now you're thinking to yourself, as counsel for the child, I have to represent that child's wishes. They seem mature enough to do this. It's a very obviously unpopular viewpoint. Is there a way for the court to understand that I can't do best interests, but somebody else better? But here's the thing. If you even ask for a GAL, are you then going to be disclosing a client confidentiality? So unless the judge recognizes there might be some kind of conflict and appoints the GAL, because that turned out to be a okay resolution at the time. But again, if counsel had brought it up, then counsel would have ended up disclosing a conversation that's obviously confidential. And I don't know if that's where you were going when you brought up role of counsel, but those were the role of counsel issues in this case. And that and they typically do come up in cases where the children are a little bit older, but there are very serious allegations. But again, Massachusetts is a client-directed model of child representation. It's not a best interest model. Best interest only goes to GALs and to and comes in as a standard, in cases in terms of terminated parental rights, for example. Tim.
What was that? I missed that. Massachusetts is a
client-directed model. So that's role of counsel, John. So we were back at, is there any resolution? Now we know Cassandra, as the investigator, had summarized and then mentioned that her recommendation was that ultimately, perhaps with therapy and with other things in place, that reunification was possible. We heard that the children were doing well in school, had been doing well before. Well, now there was no obvious change or trauma in the condition at all. So there were a lot of good things in terms of, could you possibly keep this family together? Is it possible, however, For example, Lester and John, you at least counsel. What would you throw out as an offer? And you have to throw it out for both of the cases. Let me throw another nix into the mix. Which case goes first? They're both pending. And does it matter? And what would be better for your client in terms of which case goes first?
I would think the one with the higher standard, if that went first. Well, it's a good question, because you might reveal, things might be revealed in the criminal
Yeah, no
trial.
matter. Each way is really tough. For example, we already saw that from the first 51A report, the DA is getting a 51A, the 51B, the service plans. So stuff has already been funneled to the DA. Your client goes to court and gets convicted, all right? If your client gets convicted, how can that be used in the care and protection case? What case have you seen here that
I think
can it come in? And if the conviction can be introduced to come in what way can it come in? In other words, how does the judge use it? Rita?
In the Carla case.
Carla or Carlos?
Carla, Commonwealth, adoption of Carla. It was in
Rebecca it was related to the mother, and the father had a criminal conviction, so I don't think that's right on.
Take a look at Jennifer. Remember, that was the case we discussed for another issue on Tuesday. We discussed it in terms of the judge can't substantively rely on statements as proof of the abuse if they came in only for state of mind. Remember the children there where there were adequate statements and the anatomically correct dolls and so forth. But in that case, also the father had been. You have it, Ash?
I was just going to say it could only come in to the fitness as a parent.
Yes, yeah. Well, only is a big deal because that's what Jadita would do. She offer in evidence, a certified copy of it. And in fact, in Jennifer, it wasn't even his child was babysitter and still came in. So she'd be offering in evidence his criminal conviction. Again, that in and of itself is not. It can't be just that. But it's certainly a factor that the judge would consider relative to his fitness as a parent. On the other hand, what if the case goes the other way and the C&P is heard first? I'm just wondering, what again, as Lee's attorneys, if you could somehow direct the course of which proceeding goes quicker, which one would you rather have, Lester?
I would rather have the criminal case proceed immediately because the standard.
That's what John was saying too.
Standard is higher.
Yeah,
and in the civil case, in the care and protection case, the standard is lower, and my sense is the out-of-court statements. The hearsay statements are going to be admissible.
In the care and protection case?
Yes.
Yeah, and again, the only, not flaw in that, but if your client does get convicted, it's going to be used. But you're absolutely right. The holes in the case relative to the criminal case, In other words, the whole, in the district attorney's case, in terms of the evidence the district attorney has. 23381, again, if all of those safeguards are met, Jason's statements might come in. Alicia's, again, but just the excited utterance perhaps, because even state of mind may not come in the criminal case, because the kid's mental state is not at issue in the criminal case, it's at issue in the care and protection case because it's abuse and neglect of children. So you might not even be able to get Alicia's or any of those state of mind sort of exceptions in the criminal case. So I agree with both of you that you would probably be pushing for the criminal case to go first. And remember the whole first complaint, fresh complaint issues as well. You don't have the corroboration of anyone else. I'm sorry, of the victims. So whether you're in the context of the criminal case or the care and protection case, if the other side is going to be, if the department or the state is somehow going to make the argument, oh, judge, it's not hearsay, it's coming in as first complaint, then the defense's argument should be, no, it's not. Look at Amaral, look at Avila's. You've got to have the victims testifying as well. The person that's testifying to the first complaint is merely corroborating what the victim would be saying. And then we also discussed, again, in the criminal case, if the district attorney was looking for, some other method, say the children wanted to testify, but then, the whole issue of them being traumatized by the court testimony and whatnot, there has to be, it's highly unlikely in terms of the Massachusetts higher standard regarding face-to-face. Even though, the Bergstrom Court and the Johnson Court did say that, well, we're not going to say it's absolute across the board in every situation. So, following Maryland v. Craig, let's look at it case-by-case basis. Necessity, is there a compelling need? But at the same time, balancing and keeping in mind defendants' right to face-to-face. So again, the defense seems to have what we call a good case, in terms of maybe being found not guilty. Yes.
It almost seems like in the care and protection case that it's a good case in the sense that, well, I wonder what other things can prove the reliability of, because that's one of the things that I was reading about in the Rebecca case was
right.
That the judge he relied on the out-of-court statements, but he couldn't find another means of corroborating them or showing that they were reliable.
Janita, what do you think? If you were going to make an argument that Jason and Alicia's, or at least Jason's, statements were reliable.
Well, definitely the first or fresh testimony, because they stated that many times children, they will recant once they realize that the family could be separated or they won't go back to their parents, that they start to recant their statements out of fear.
And I don't remember if this was on the video or not, but statistically, children don't often fabricate abuse, sexual abuse by a caretaker, and do often recant, as you said, because of feelings of guilt, tearing the family apart, etc. Could the judge rely on that for reliability?
I think they should, along with getting these children tested, like psychologically, and all of these things together, because it's difficult to have like one by itself. For example, in getting those children tested to see whether they would be traumatized if they come into court to testify. If they will be, then of course take the first responders' testimony saying that this is what they testified to.
Mm-hmm.
And then their behavior too with the anatomically correct dolls. There are certain things that I don't believe children would know, especially when it comes to these sexual acts. So where would they have gotten it from, you know, as being a child? So all these things they should take into consideration together.
Yes, and that's a big thing, the children's behavior, whether with the dolls or, you know, sexually inappropriate behavior that children do not necessarily exhibit.
Right.
Who just had a hand up? Oh, Lester.
My client has a right to inquire as to the children's recantation.
Right.
Furthermore, Section 26 permits the judge to grant my client custody with supervision if he or she thinks it's necessary.
So, what are you offering the department?
My client is in therapy,
Okay.
and we will continue to comply with that requirement.
What would the service
I would
plan
offer
say
the
to
service plan. I would say he should be on a service plan because this could be a problem that
Yeah.
would happen again.
But what if the
He's
service
in therapy.
Yeah.
service plan, you know, / therapy or whatever it is, he needs to admit,
He's willing to cooperate.
and the DA gets the service plan?
Well, then he should go
Then
through
he did it.
You
Should
see
go through
what-
the criminal
Right.
trial first,
Tim?
and then he can admit to it.
What's that? I'm sorry.
He goes through the criminal trial first and gets that done, then he can admit to it
If he's
before the
not found
service
guilty.
plan. Yeah. If he's
So,
not-
and that's why we're here together, because you know, it's, do you want to go through with the trial? Or is this, you know, and there's nobody here from the DA, but what offer would you accept on the criminal case to, you know, not bank that, you know, you might not get the not guilty. Too negative, sorry.
Well, my client certainly demands custody of Jonathan. There is no allegation against
Go for it all.
my client's
But-
conduct with
and
Jonathan.
You've got the investigator behind you in terms of her final recommendation. She's saying not right now, but she's certainly positive. So in what way could your client not go to jail, or not go to jail for a long time, and ultimately get custody? So we're looking for, you know, no incarceration, or at least, you know, maybe not no incarceration for a long time, and reunification. Is there a way that that could happen, Nadesh?
I don't think so, because in Emerald, is that how you
Emerald, yes.
The judge, I believe, he relied on Dr. Vinnie's testimony, because she said, I don't know, he or she said that usually those children around Jonathan's age, sometimes they don't disclose what happened. You know, they delayed on telling exactly what's going on because of fear, or
That's right.
you know, of threats. Probably the parent, you know, told Jonathan, if you say something, I will spank you, or I will take your toys away, or whatever. So I don't think most likely the judge will not grant the custody of Jonathan to Lee.
And the fact that even though there's no evidence of sexual abuse, the judge isn't going to wait until there is evidence of sexual abuse. So he can take away parental custody based on what happened to Alicia and Jason.
Now, here's another issue. It's possible that you could get a not guilty without your client testifying, because he doesn't have to testify in the criminal case. Is it possible that the department cannot prove its case without your client testifying in the care and protection case.
I think, because there's like that negative inference if you don't
So
testify.
if Lee doesn't testify in the care and protection case, so there's another notch that the judge can depend on in his or her rulings. The judge can draw an adverse inference of unfitness. Again, it can't be just that, but among all the other things. So that's another issue.
Is that because the judge is pretty much saying you're not willing to fight for your child, or?
It's because allegedly, again, that these are not criminal cases. So the Fifth Amendment right doesn't apply to the case, which kind of, I'm sorry, sucks. Because again, he's subject to criminal prosecution because of the, alleged acts, but yet the judge can still draw that adverse influence from his failure to testify. The same sort of thing. The DCF puts all of these items in the service plan that have to do with him admitting to the acts that the district attorney then gets as, ammunition for the trial, for the prosecution.
So you're saying it doesn't testify, he'll lose in the care and protection?
Not necessarily lose, but it's an inference of unfitness.
Right. I just want to make sure you weren't talking about the criminal. You were
Right. That's correct. So the Kaldis case, in the Kaldis case, the mom was not protecting her children, and there's more than the Kaldis case, but that one brings to mind regarding the sexual abuse. But by the time the case kind of came to trial, she had made some progress, and in fact, I think the SJC even says significant progress, so that her rights should not be terminated. What if by the time it does come to trial, Lee is coming around a little bit? Would that help, Jadida? And in what way should he,
I would say it would help, like, if we were moving for termination of parental rights, it would probably help. Maybe we wouldn't move for termination.
Mm-hmm.
Maybe we'd still seek custody and, continue with the service plan.
And what would you consider significant progress?
It's tough. It's hard to say because, okay, we can say he's improved, but he doesn't have the kids in his custody. So how do we know that he's really improved? The kids go back and then he relapses. So it's I don't know.
Well, is he now making statements or intimating that there was more than this, shower incident, and that he needs help, and he would be, willing to engage in therapy, even perpetrators therapy, and that sort of thing.
Those things. If he admits it, of course, and then now we know where he needs help, what areas he needs help in, and following up with his appointments to go to these things. Yes.
Okay.
But then there's still always going to be that fear that, okay, yeah, he's going through all of these therapies and so on and so forth without the kids in his presence. Now when they come back, what happens?
Tim?
It just seems to me like he pretty much admitted it. He's just not admitting details because he knows if he does, he's going to jail. And he
That's right.
said, I'll go into
That's
therapy.
absolutely right.
So you really can't take 2 further steps, or otherwise he's going to jail. So he's like, yeah, I know this is wrong. This is all I'm saying I did. I'm not getting into details. I'll go to counseling.
Exactly.
Short of that, all he can say is, yeah, it's sexually abusive, and he's going to jail.
Exactly. What if somehow, is there a possibility of admission to sufficient facts? A lesser included offense, and the department also going along with perhaps adjudicate them in needed care and protection, but temporary custody to DCF with because they're under 11926, the review and determination is in 6 months, so that's not that far, and is there a possibility, if he does admit to sufficient facts on a lesser included offense, and he'd get a suspended sentence rather than incarceration. Lester?
My client disputes the assertion of the district attorney. My client acknowledges the shower incident and the inappropriateness of that, but we don't stipulate to any other incident.
Well, could the shower incident amount element-wise to say either indecent assault and battery, any of the lesser included offense to rape of a child under 15?
And furthermore, the medical testimony or the medical record is that there is no
That's right.
no violation of the child.
That's right.
So we dispute everything beyond the shower incident.
I wanted to make a comment that it seems like if you're advocating and you're Lee's attorney and you're advocating that, well, clearly from the record in a way, Jonathan doesn't have any awareness of this.
Mm-hmm.
But what's to prevent somebody who's looking at it from saying, well, Jonathan is very young and undeveloped, and maybe at some point, I mean, it's like you're saying he's a good guy based on these facts, but somebody can look at the same facts and draw a completely different conclusion.
Yeah, from the care protection end you're talking.
Yes.
Yes, yes. Again, and the SJC would honor that that strategy because the judge is not, again, and I use the language of the SJC again, we don't have to wait for disasters to happen. We know that, he sexually assaulted and or raped the older children. That in and of itself might even be enough that Jonathan is in the same household. And again, he may, if Jonathan is older, do the same thing to Jonathan, and I think that's what you were saying.
Yes.
All right, let's wrap it up. Looks like there's no deal. And that's in reality what happened. There was no deal because he did have, again, all these holes in really both of the cases. What case you think went to trial first? Go ahead, you see the case?
Karen.
I don't know. I mean, as I stated,
What do you think? Just take
I
a
would
guess.
hope the criminal case was resolved first,
Okay.
because that would be in our favor to keep the children.
Care and protection. Care and protection.
And then
Care and protection.
it was the care and protection went first. But you're right. I mean, you're right. You have a right to speedy trial as a defendant. But the care and protection case went first. Oddly enough, there were other events in the care and protection case. The children were in Uncle Tony's, well, not custody, but he was the placement, and his wife was pregnant. And lo and behold, there was another possible placement, and it was Lee's girlfriend who had a son. So the children lived with Lee's girlfriend for a while. All right. What do you think, Kathy?
Was there any evidence that son was?
Yeah. Mm-hmm.
Okay.
51A was filed. Girlfriend broke up with him. It's interesting because
Wow.
one of the cases that you have,
What happened? The uncle did something to him too?
No.
Yeah.
Lee's girlfriend.
Oh,
Wait, Lee's girlfriend or the uncle?
she had a son.
Right.
Wait, who
I
was
saying
the
not,
85 again?
Tony didn't abuse him. Lee did.
Lee did.
Right.
Yeah. One of the cases that you read, the appellate court, I can't remember if it was the SJC or the appeals court, mentioned that that there wasn't enough evidence regarding the mother. That was when the children were sexually abused by brothers and boyfriends, and the expert mentioned that the children were suffering from scabies, and that she put medicine on the children. That was actually Lee's defense in terms of the 51A that was
That he was
filed
that he was
regarding
putting
this
boy
young boy. that the young boy had poison ivy and that he was putting medicine on him. So the children would then, so they started with, you know, the grandmother was a quick one, then Uncle Tony, then the girlfriend, I forgot what her name was. Then the children were actually then placed in a foster home, all three together. And that was a very good thing, because even back then, it's difficult to place very young and older siblings, or any siblings together. It was a foster home that was then ultimately even, DCF went through recognizing it as a pre-adoptive foster home. You know, there's different levels, okay? And but I'm sorry, they weren't in the foster, at the time of trial, they were still
With Tony.
They were still with Tony at the time of trial. So let me just go back to the time of trial and what the judge relied on. So the investigator's report comes in and it's used, and it's part of the, you know, findings of facts and rulings of law on which the judge concludes that parent is unfit. At the time, there was no statutory issue, so, you know, I used it for purposes of a class, so we could talk about Chapter 233, 81, 82, 83. That statute wasn't enacted at the time, and by the way, Jason was over 10 anyway, so we didn't really deal with that. We did deal with the hearsay exceptions, and we dealt at the time with fresh complaint. So when Ellen and Kathy were allowed to testify, but when they were going to call to the stand, and you know, Lee and children's attorney are objecting, all kinds of arguments are ensuing, because Lee's attorney, I mean, the children's attorneys are saying my clients aren't going to testify, and the judge is letting it in anyway, calling it fresh complaint, in spite of the fact that he's told that the children are not going to testify. So again, so he lets those two testify, and uses the initial interview, the substance of the substance of the initial interview in his findings of fact. He also, I'm trying to think what else he relied on. Again, the same issue that we discussed relative to Jonathan. They found, you know, all three children in need of care and protection, including Jonathan, because again, he wasn't going to wait for Jonathan to be abused. So it was, you know, all three. So he finds them in need of care and protection. And then the issue with the placement occurred later on, because again, they needed care and protection but didn't terminate parental rights. So we're back into court still all the time. In the meantime, you know, the criminal case is still pending. Then the girlfriend thing happens. Then they get sent to the foster home. Well, then they start talking to the foster mother. They feel safe. A period of time elapses. And that's what hurt him. The criminal trial should, and you two are right, the criminal trial should have gone first. Because he had a really good chance of getting a not guilty because of all these holes. They start talking. They ultimately, in the meantime, when the care and protection case ended, everybody filed an appeal. Children's attorneys, Lee's attorneys, based on, you know, the judge, and you know, the standard review was whether the judge clearly erred. And on the law, he did it. Because there, again, even with the lesser standard of proof, clear and convincing evidence of unfitness, it wasn't enough. Again, the whole trial was all hearsay. It was all hearsay. The investigator, the cop, the social worker. Even to the tune that the court also heard over lengthy questioning how leading and terrible that first interview was. Really, you know, shocked apart. Poor Ellen, the social worker, was was devastating cross-examination on the stand by these attorneys. So anyway, appeals court, it's docketed in the appeals court. But again, as I said, while it's docketed in the appeals court, time is going on, they're healing, they're feeling safe. They tell foster mom, criminal case goes to trial, Alicia and Jason testify. They testify, and not with little tables or behind the screen.
Face to face.
Face to face. He gets found guilty. Not only here in Massachusetts, what do you think? That he gets on and after charges down in the, wherever he was from, I forget.
Carolina, right?
Yeah. So that's how the.
Why did
case ended.
Lee's girlfriend lose custody? Is it because she
No,
felt-
she didn't lose custody.
She
She
felt
filed a
acknowledged.
51A
Okay.
because her son said Lee was groping him.
All right, so it's not like she failed to acknowledge
No,
sexual
no,
abuse.
no,
Okay.
no.
So Lee's
Remember, the key
incarcerated?
is with child sexual abuse, unless there's any physical evidence, really no one knows the truth except the victim and the perpetrator.
Was Lee offered a deal?
Yeah, what we just did was done. He didn't, just like these guys did, he didn't take it.
Would think.
But the deal was harsher, you know, it was jail time, it was admitting to stuff, it was losing custody, it wasn't that much of a deal.
Yeah.
I didn't blame
It's better
him.
than a guilty.
What's that?
It's better than a guilty. That's what
Depends
you
on
got,
how
right?
close it was.
Yeah,
It was pretty much almost the exact same thing as going to trial. or close
yeah,
enough.
yes, absolutely.
I'm just curious as to how extensive the therapy that these kids went through. Like, do you?
They didn't go through any therapy, nothing.
Wow.
Just the
Because they
healing.
recanted from
Oh,
the
that's right.
beginning. So there was, you know, and they just stuck. I remember, who was it that said it to me? I think it was their first attorney. The first attorney was a good attorney that got fired, you know, the court-appointed attorney. He said to me, Paula, he said, these were the toughest clients I've ever had. Toughest in terms of, you know, they knew what they wanted at the time. And this was their wishes, and they were sticking to their story, and this is what they wanted to, you know, and they maintained their composure. As I said, there wasn't even a period of time where they did badly at school, or were missing school, or were sick, or there was no outside evidence of anything. Added to that, the terrible leading interview that was held that really screwed up the case.
Does it often happen that, well, I'm sure it does, because we read about it in the paper, people eventually come forward when the time's right.
Right.
But because they already recanted their statement, and now even though they're testifying because of, I guess, double jeopardy, they couldn't go back, right?
I don't know what you're saying.
Okay, because the kids recanted their statement, saying that their father didn't abuse them, but now they're coming out after they're they're in foster care, and they go and testify against their father in trial. So nothing can be done because they already said he didn't
Nothing
abuse them.
can be done about what? I
About
still
their
don't-
father abusing them.
Oh,
And
yeah,
saying-
he went to jail.
Oh, but I thought it was just for the Justin.
Oh, no.
Child
Okay.
protection.
No.
First.
This was
Alicia and Jason.
his kids.
Okay.
Yeah.
So what happened with the Justin situation?
That-
Justin
He disappeared.
I
He
forgot,
disappeared.
yeah. Wow.
Very odd.
So is he still in jail
Oh, yeah. I was very good friends with his attorneys, too, and I learned, and he wasn't 100% sure about this, but he had heard that, remember at the beginning, Alicia said something about when I went back to live with my dad. thought that the mom had actually killed herself. Having found out that,
That this happened.
that she drove her car off a bridge.
Allegedly because of the knowledge that
Right,
under her guidance or
Yeah.
supervision,
exactly.
the stepfather was
Yeah.
doing this?
Yeah.
Should have killed him.
That certainly doesn't help the children.
No.
No,
At all.
no.
Terrible.
But you saw in these cases, the non-abusing spouse, whether it's CSA or domestic violence or both, they always have a very difficult time protecting the children because of what they're going through.
They feel like they failed as parents.
How were they when they were testifying? Did they show any?
They were terrible witnesses. I'm surprised it's common without a conviction. They
Yeah.
were scared, they were facing him. You know, all the reasons why children shouldn't testify, and
Yeah.
there should be, as Jeremiah said, modifications. Right.
What I was thinking earlier, Professor Kaldis, is this is not exactly relevant, but to waive rights, it has to be a knowing
Yes.
and intelligent
Waiver.
waiver.
Yeah.
And this recantation by the children, even though they stood by it, I'm stepping out of my role as Lee's counsel, but
Take a look at, did you guys get to read any of the articles? I was involved in a conference about a year or two ago, and we wrote like a bench book for judges. And I authored a little chapter of, of the role of counsel. Not the role of counsel with Judge Blitzman, not that article, but there's another one, Nora Sanchez.
in the materials?
In your materials. And really, even in spite of that we're client directed, is there a way that when you meet, you and your child client have a different relationship than you and your adult client? Even though, as I said, Massachusetts is client directed. If there's a way, because lawyers are advisors, as well as advocates. If you can develop the relationship in such a way that you're helping your child client to get the help he or she needs, to advise him or her about everything, and to be with her every step of the way, you can be engaging in getting the therapy and doing what, needs to be done, but at the same time not sort of violating and becoming a best interest. You know what I'm saying? So in the end, it's still the child's choice, but that you've properly developed the relationship and given the advice so that the child does take this route. So read through that little bit. That's a short one. It's just like little bullets. I think it was at the end of the materials.
is this appointing legal counsel for children?
Yes, that one. Yep.
Is it on West?
Oh, yes, the bullets. Right.
It's on your it's in your CD.
Oh, okay.
Yeah, it's somewhere, and I don't know if it's at the end of the materials or if it's in the middle somewhere.
I have it in the original syllabus, page 296.
Are you looking at me? I don't know. I don't have it. I don't print out the whole thing.
Appointing legal counsel for children in domestic relations.
Is that the one
Yeah.
with Nora Sanchez?
Yes.
Okay.
Yes. Yeah. So that should answer what you just brought up, Lester. Now, I've emailed you guys the entire day class, and I've put the rest of the day class either listens or, obviously they're going to read the email. I took the liberty of actually assigning your roles for the Tuesday after break, and I emailed you the IFA assignment because in the materials, I only have it as one exercise of Superior Court, but we're actually going to do 2 mini exercises. One is going to be the DC, the hearing by the hearing officer that's going to determine whether the 51A report was adequately supported. And then from there, we go to the Superior Court argument. And I also emailed you a revised syllabus. And I also had Nikki Coyne put the revised syllabus online as well. Okay.
For anyone who's looking for that article, it follows adoption of Daisy.
Oh, thank you. Thank you.
Adoption of
and
Daisy.
Was Daisy the last case?
I don't know, but it's after adoption of Daisy. Immediately thereafter.
I think it's sort of in between.
Let's see.
Yep.
It's the last adoption case.
Okay. Okay. So that means it was originally in the old syllabus after the first set of child sexual abuse materials. Thank you, Lester. All right, I'll see you all after the break. Have a great break.